To understand the architecture of Indian maritime law, we must look at the mid-20th century conditions that necessitated its first major codification. This comparison reveals the shifting objective of the state. In 1958, the preamble explicitly prioritized fostering the development of an Indian mercantile marine. The 2025 preamble refocuses the law to ensure compliance with maritime treaties. The 1958 Act functioned as a post-colonial developmental tool. Its primary function was to build and maintain a domestic fleet for a newly independent nation. Over the following 67 years, the global shipping industry consolidated around strict, overlapping international conventions administered by bodies like the International Maritime Organization. To keep pace, the 1958 Act was repeatedly patched with reactive amendments, eventually leaving its original administrative structure unable to support the weight of modern regulatory requirements. The 2025 Merchant Shipping Act repeals the 1958 statute in its entirety, replacing it with a new legal architecture. We will analyze this rewrite across three specific domains: the transition to a rights-based labor framework, the native integration of international treaties, and the establishment of pre-funded environmental liability. Surviving in the modern shipping industry requires fleet operators to base their operational models entirely around these 2025 compliance frameworks. This photograph illustrates the reality of maritime labor in the 1950s. The legislation of the era reflected strict operational hierarchies. The 1958 Act consistently used the term seaman. The 2025 Act replaces this with seafarers. The semantic change aligns the domestic text directly with the terminology of the Global Maritime Labor Convention, known as the MLC. The 1958 law operated as a master-servant legal framework. Its labor provisions were designed primarily to enforce operational discipline while at sea. Look at the left side of this ledger. Section 191 of the 1958 Act explicitly criminalized standard labor actions, carrying penalties for desertion and absence without leave. The 2025 text discards that framework. It establishes rights-based mandates, anchored by sections like Section 67 regarding repatriation. To enforce this right, Section 67, subsection 2, requires ship owners to provide documented financial security to cover the costs of that repatriation. The new act codifies specific guarantees, legally mandating strict hours of rest and entitlement to paid annual leave. This financial mechanism specifically targets the modern crisis of abandoned seafarers, crews left stranded at foreign ports when shipping companies declare insolvency. By legally mandating the security up front, the state transfers the ultimate financial risk of crew welfare directly onto the fleet operators' balance sheets. Enforcing international law within domestic borders requires constant, precise statutory translation as global treaties update and the maritime industry evolves. This diagram shows how the 1958 Act managed external treaties. It relied on reactive amendments passed by Parliament every time a global standard changed. The 2025 Act structurally embeds these treaties natively. This fragmented approach created a persistent legislative lag, opening jurisdictional loopholes for fleet operators, while domestic law caught up to international agreements. Clause 15 of the definitions section defines the word convention simply as any international convention to which India is a party. This single definition creates an automatic legal hook. When a new international maritime law is signed, it is instantly enforceable domestically without requiring a piecemeal amendment to the Act. Section 307 utilizes this definition to establish a strict hard gate. No vessel may enter Indian ports or territorial waters without complying with these conventions. This operational gate enforces exact compliance metrics for vessel construction, safety equipment, security protocols, and pollution prevention. To manage the immense administrative burden of this oversight, the Act formally recognizes the use and maintenance of electronic records for rapid auditing. The operational lag between international treaty creation and domestic legal enforcement has been eliminated. Modern maritime accidents carry severe ecological consequences. The 1958 Act contained no comprehensive statutory framework for managing catastrophic environmental damage. Regulators were forced to rely on generalized unseaworthiness clauses to process the legal fallout of massive oil spills and chemical leaks. The 2025 Act solves this by introducing a precise, actionable legal definition for pollution damage. This flowchart maps the new operational response. A marine casualty instantly triggers the intervention of an appointed nodal authority. Under Section 228, this nodal authority bypasses traditional jurisdictional delays to issue direct binding mandates. The state can legally force the vessel operator to execute immediate cleanup actions, or it can initiate the response itself and bill the operator. Section 229 ensures these bills are paid through the strict mandate of maintenance of compulsory insurance. This guarantees that the state and affected local parties have a direct, pre-funded avenue to recover costs for maritime claims. Operators can no longer utilize shell companies to abandon compromised vessels and evade the capital required for ecological restoration. Environmental liability is no longer a protracted civil dispute. It is an automated, pre-funded statutory mandate. This transition from 1950s-era developmental goals to modern, compliance-first enforcement marks the end of a developmental era in Indian maritime history. Indian maritime law has evolved from a closed domestic statute into an open, compliance-driven framework. Fleet owners must adhere precisely to the Maritime Labor Convention, calculating crew welfare, rest hours, and repatriation as non-negotiable liabilities. Environmental impact mitigation protocols trigger immediately upon an incident, stripping away layers of jurisdictional delay. And maintaining compulsory financial securities is now a statutory prerequisite for holding a legal license to operate. The 2025 Merchant Shipping Act closes the liability gaps that defined the 20th century. Ultimately, any vessel navigating Indian waters today must operate at the absolute edge of strict global maritime compliance.